Hello everyone, welcome to KPS की Kanooni Kaksha. I am Kohina Jain. Today I will taking a topic on bail. Moving ahead. First we have to understand what is bail. A bail refers to a person temporarily released from a custody after being charged. The basic principle of bail is a rule and jail is an exception. It means a person should get bail in the every circumstance, but also there is some expansion where person should be in jail for the benefit of the society. There are following categories of bail. First, bail in bailable offense. Second, bail in non-bailable offense. Third, anticipatory bail. Fourth, regular bail. Fifth, interim bail. And last one is default bail. Moving ahead to bail in bailable offense. So if any person has committed any bailable offense, he is entitled for bail as a matter of right. Bailable offense is defined under section 2 subsection A of CRPC, and also police as well as magistrate can grant a bail to a person. If police refuse to grant bail, then accused can apply for bail before the court having jurisdiction over the matter. Section 2A also defined bailable offense. Person accused of bailable offense and is arrested without a warrant, he can claim bail as a matter of right, and police also cannot refuse for this. Bailable offense are relatively less serious offense and are punishable with imprisonment for a term of less than 3 years or with a fine only. It means if a person is charged with an offense whose punishment is less than 3 years, then such offenses is known as bailable offenses. The example of bailable offense are cheating, public nuisance, etc. Also, under section 436A of CRPC, it provides that if a person is under trial and detained for a period, and he has fulfilled his half of the punishment, which is half of the punishment, it is a matter of right that he should be discharged on his personal bond or with or without sureties. Now, next is bail in non-bailable offenses. So, under section 437, bail in non-bailable offense is provided. A non-bailable offense is a crime in which the grant of bail is not a matter of right. It's only the discretion of the court that bail should be granted to an accused or not. But accused has to seek the permission of court, and it is the discretion of the court. The trial of such offense of non-bail offense should ideally concluded within 60 days from the date which was fixed for taking evidence. If not, the accused must be mandatorily released on bail if he was in custody. If he is not released, the officer or the magistrate must record the reason for doing so. So this was held in the case of Raman Kumar versus Punjab. If investigating agency or a police has not concluded investigation or has not has not has not has not collect sufficient evidence to prove the person's accused, then the person should be granted bail. Section 437 of the CRPC also contains some exception, such as the court may grant bail in cases where a person is under the age of 16. It means if he is a minor, or he or she is a woman, or is a sick person. In all these cases, person should be granted bail. The example of non-bailable offenses are Section 302 of IPC, that is the punishment of the murder. Third one is anticipatory bail. Section 438 provides that if a person is in apprehension of his be arrested, he can file an application in a court, in a session court or in a high court for the bail. So the grant of anticipatory bail is a discretionary power of the court, and court may grant bail after considering the nature and the gravity of the offense, the incidents of the accused and other relevant factor. Gravity of the offense and incidents of the accused, these two are the grounds where court considering the nature and then grant the bail. The court may also impose certain conditions while granting bail, such as surrendering the passport, refraining from leaving the country. So these are the conditions that courts put on the accused person before releasing him on bail. Then next is regular bail. Section 439 and 437 both talks about the regular bail. Accused can apply for regular bail under section 437 and 439. Also, the court release the person who is under arrest from police custody after furnishing the bond. So this is a simple bail. When a person is arrested immediately after arrest, he can file application in a court for releasing him. Also, a regular bail can be filed anytime after the accused is taken into custody by the police or investigation agency for seeking release of the accused on bail from the custody. Next is interim bail. Interim bail is a bail which is granted for a temporary and a short period by the court till the application for the anticipatory bail and the regular bail is pending before the court of law. It will be granted on a certain condition that accused needs to be fulfilled. The interim bail can be extended, but if the interim bail expired, the accused person's freedom will be revoked. It means the period for which interim bail is granted, if it is expired, the accused person again sent to the jail and he will be taken into custody and a warrant will be issued against him. The essentials of interim bails are: it is granted for a short period of time, it is granted when an application of anticipatory bail or regular bail is pending in court. Once the time period for bail is over, the accused will be arrested without a warrant. There is no specific process of cancelling of interim bail. These are the essentials. Next one is default bail. Section 167, subsection 2 of the Criminal Procedure Code 1973 empowers judicial magistrate to authorize custody of an accused person in cases where an investigation cannot be completed within the 24 hours. If a police or investigation authority has not completed their investigation within a stipulated time, then person has a right of a bail. It further contains that if the investigation is not completed within a time, the accused is to be released on bail, whatever may be the nature of the accusation against him. So, in case of Surinder Singh versus Singhara Singh versus State of Punjab, the Supreme Court held that life convicts who have undergone at least 5 years of imprisonment and at least 3 years should be after conviction, he should be released on bail. For hearing of pending appeals, they can make further application for this purpose. Now, who can grant bail? First, magistrate or police officer under section 437, if a person is arrested without a warrant in non-bailable offense, he shall be released on bail before the magistrate or by the officer in charge of the police station. So both can grant bail in case of non-bailable offense, and in case of bailable offense, police authority himself can grant bail to the accused. And there are also some exceptions in which case bail cannot be granted, and these are the death or imprisonment for life. Next session or High Court. Under section 438, High Court and Session Court can grant bail even in cases where magistrate cannot grant bail. So there are some conditions for granting bail, and these conditions are: if application made against the applicant are untrue, baseless, and the complaint was filed with the intent to harass the applicant or accused. Second condition is the applicant is an Indian citizen with clean background and no criminal history. Third, the accused applicant is the family sole provider. Jailing him on the basis of false accusation would not only ruin his life but also have a negative effect on family. The accused does not pose a direct threat to public safety and peace at this time. Further conditions are: the accused agrees to cooperate completely with investigation authority and make every effort to appear in court when necessary. The accused would refrain from destroying and tampering with evidence, etc. So these are the conditions a court consider while granting the bail. Next is bail bond and surety. Bail bond is a written promise signed by the offender or a person who gives surety of the offender's presence in the court. when called upon to pay a certain amount fixed by a court or a police officer. So it is a written promise, and the person who is giving surety, he has to sign this bond and also give surety that he will be present before the court when he will be calling. Next is surety. If a court is not satisfied with a person or accused promise to appear in a court may decide that it needs an independent surety to guarantee the person accused appearance in court. If an accused himself cannot satisfy the court that he will be present before the court when he will be calling, so he has to give some other person as a surety. He will guarantee that the accused will be present in the court. He is the one who pays on behalf of the offender for the bail bond when the offender is incapable of furnishing his a personal bond. So it's a guarantee that court is required by the accused person so that there is no chance of offender will be escaped from the country or any other issue. Next, Section 440 of CRPC provides that according to the circumstances of the case, court can fix a reasonable amount of bail bond. So it means that for releasing the person, the court ordered some bail bond. These amounts should be reasonable and it is fixed by the court according to the circumstances of the cases. Next is Section 441 states that the bail bond should be signed by the accused person, and it ensures his presence when at the time mentioned in the bond or until. Thank you.